Good afternoon and welcome to part 2 of our webinar series, Lunch and Learn, on custody litigation. Today we're presenting information on 4 topics that often result in custody litigation. The first topic is parental alienation, which will be presented by Merrill Haft. The second topic is mental illness, presented by Shane Duffy. The third topic, domestic violence, presented by Maxine Donskoy, and we will close the topics with allegations of child sex abuse, which I will present. Again, we want to remind you that opinions expressed are our own, strategies expressed are our own. We in no way represent any other law firm or the court system. I want to, before we make the formal presentations on each of the topics, give you some ideas regarding various cases that we have litigated here in our office that involve each of these topics. I'll leave the discussion of cases litigated on allegations of child sex abuse to my own presentation. On issues of parental alienation, I have represented parents, fathers who were accused of alienating or accused the mother of alienating the child against them. I will say that strategically in those cases, because New York is an attorney for the child state in which the attorney must present the child's positions to the court, you do not want an attorney for the child presented if you are representing the parent who is accusing the other of alienation. The reason for it is if there is an attorney for the child and the child clearly says, I hate my dad, I don't want to see him, most likely that attorney will have to go into court and express that to the court, which is clearly not helpful to your client. What you want is a forensic exam immediately before there's any representation of any children. I've also represented a mother who was accused of parental alienation. I represented her on child support issues where there had already been a finding of parental alienation against her. And the father in that case was seeking to essentially get out of paying child support or contribute to the child's college education. Because there was a finding of parental alienation, the court vacated the order of support. So very important to those of you who may be being accused of parental alienation. It can result in serious financial repercussions. And also I might add that spousal support is often suspended because of parental alienation. I will also mention that parental alienation is often used as a defense against allegations of both domestic violence and child sex abuse. With regard to mental illness, I have represented mentally ill clients. There's a distinct difference here. The clients who acknowledge that they have a mental illness, seek treatment, take any prescribed medication, and do everything that they can to be a functioning part of society, do not have to worry. They do not lose custody of their children. But parents who deny that they have a mental illness leave themselves open to oftentimes wild and crazy behavior that is observable by a court. I'll give 2 examples. One mother who was definitely suffering from a mental illness, in denial, painted the entire apartment black, started throwing the furniture out the windows. There were 2 little children in the apartment, ages 5 and 3. This was clearly aberrant behavior on the part of the mother. In another case, my client also refused to acknowledge that she had bipolar disorder and concocted a story that because the youngest child's bat mitzvah invitation had gone out, that somehow the FBI was going through her mailbox with the bat mitzvah returns or RSVPs, if you will. So again, aberrant, crazy behavior that the court can therefore use in a custody dispute, and certainly minimally a lack of judgment is apparent. And finally, domestic violence, the cases that involve obvious physical illness. I represented a wife and mother who the husband had smashed her face against an old-fashioned metal radiator. There were obvious bruises, lacerations, cuts, swelling. So there, the physical evidence as to the domestic violence was quite apparent to the court. When it becomes more difficult is when it is behavior that is controlling, when it's involving financial abuse or emotional abuse, that becomes much more difficult, and even more difficult when there are children involved and a court is trying to balance between what is alleged to be domestic violence and is domestic violence, and the rights of the other parent to both have parenting time with the children, as well as the rights of the children to have a relationship with both parents. With that, I turn the program over to my partner, Meryl Hafe, who will present on issues of parental alienation. And again, welcome to, I believe this is our 4th webinar. We're delighted to have you.
Good afternoon. Thank you for joining us today. So today I am going to be speaking on the topic of parental alienation and how that impacts custody litigation. So parental alienation is when one parent engages in conduct which is intended to foster the child's unjustified rejection of the other parent, and in fact results in rejection of or extreme reluctance to visit the other parent. If you think that this is something that may be going on in your situation, if you believe that the other parent is engaging in acts to alienate the child from you, you should consider how you would prove this to a court. So the standard here is preponderance of the evidence, which means that you have to show that it is more likely than not that it occurred, or that it is 51% more likely that it happened than 49%. And there are 2 elements here which you have to show. One, that the parent has made a concerted effort to program or influence the children and influence them into a campaign of denigration against the other. And I use that phrase in quotes here. It comes from the case cited below. And you have to show that the child's behavior complements the programming parent, such that the child rejects or refuses to visit the targeted parent. So this case here, JF versus DF, was written by Judge Dollinger, who sits in the 3rd Department of the Supreme Court, Monroe County. And although we are in the 1st department, I cite this case here as a starting point for someone who is looking to understand parental alienation, because it is so detailed. So this is a 61-page decision detailing the history of case law on parental alienation in New York. Parental alienation was first coined by a researcher in 1985, where the concept was linked to a parent programming a child to make claims of sexual abuse. These are false claims, sexual abuse which never occurred. So one parent was taking steps to try to convince the child that in fact the child had been sexually abused, when in fact it did not occur. And this was done with the intent to make the child not want to see the other parent. The standard since then has evolved beyond false allegations of child sexual abuse to include other alienating conduct. But without false claims of abuse, you must show a systematic or intentional effort and the standard here is where one parent intentionally engaged in the conduct for the sole purpose of alienating the child. You must have overwhelming evidence of brainwashing resulting in rejection of the parent. So New York courts have rejected the idea of a parental alienation syndrome, as it's not listed in the DSM-5. So there's no diagnosis of this type of behavior or condition, but they do agree that parental alienation exists. And I note here that if parental alienation is raised in the context of custody litigation, a defense would be, if in fact a child is rejecting one parent, a defense is that the rejection is justified. That is, that the parent who's being rejected has done something which makes it reasonable that the child's like them. So I list here some examples of alienating conduct. Now, not one of these behaviors in and of itself can constitute alienation, but taken together, or when there are multiple or severe instances of this, could amount to alienation. So, so some examples here: disparaging the other parent to or in front of the child, and allowing or encouraging the child to speak negatively about the other parent. This is perhaps the most common instance where one parent speaks very negatively about the other in front of the children, or allows others to do so, specifically with the intent to influence the children. Second here is telling the children falsehoods, such as what an unreasonable, inappropriate, or unloving parent the other targeted parent is. Setting up appealing alternatives, vacations, parties, or overscheduling a child, such that would interfere with the other parent's access. Acting hurt or betrayed if the child shows positive emotions for the other parent. So generally speaking, you're supposed to be supportive of the child's relationship with the other parent. If you act in a way that that shows that you're undermining that relationship, that could be considered alienating conduct. Also, involving the child in the litigation, or asking the child to choose between parents, asking the child to deliver messages to the other parent that are perhaps intended to hurt that relationship, can all be alienating. And finally here, telling the child you don't receive enough child support from the other parent to pay for and fill in the blank. This could be, we can't go out to dinner because mom hasn't paid child support. Mom doesn't love you. We can't go on vacation this year because, your dad is neglecting his obligations. He doesn't love you. He won't pay support. So, if you're in this situation, if you find yourself being rejected by your child, there is treatment for an alienated child. It's done in the form of reunification therapy generally, and this would be joint therapy between the child and the targeted parent. And I list two professionals here who we know do conduct this type of therapy and are well respected by the courts: Dr. Peter Favaro and Dr. April Kutchuk. And with that, I am going to turn it over to Shane Duffy, who's an associate attorney in our office, who will be speaking about mental illness.
Hello, good afternoon, everybody. My name is Shane Duffy. I'm an associate attorney here, and I'm going to be speaking to you today about the impacts of mental illness on contested custody proceedings. So in New York State, it's a well-settled law that in contested custody cases, both parties place their physical and their mental health at issue. For today's discussion, we're just going to be covering the mental health issue. So there's three common scenarios that we're going to go over, and then we're going to go over the impacts of the mentally ill parents' behavior on their custody prospects in a contested custody proceeding. So the first scenario is here on the slide. This is scenario A, and this is where one parent admits to having a mental illness. A parent who admits to having the mental illness will generally make their treating therapist records available, and people who make their records available and who are forthcoming with their mental illness and continue taking their any prescribed medications and follow any treatment regimen that they're given tend to have better outcomes due to their openness. The openness of their treatment and their mental illness reflects well on their parental fitness, and that's one of the key things that the court is looking at when there's allegations of mental illness. So A quick note about treating therapist records. The mentally ill parent would have to execute a HIPAA release, granting the other party and perhaps the court, if the court wishes, so that they have access to the records. If they refuse to sign the HIPAA release, the other party can seek a court order by motion, asking the court to order that the records be made available to the other party. So next we'll go through scenario B. And this is where one parent accuses the other parent of having a mental illness that the other parent just does not acknowledge. So if the other parent continues to deny they have a mental illness, and the accusing parent can point to some aberrant behavior, abnormal behavior, or behavior that's just indicative of mental illness, the court might potentially appoint a forensic evaluator. So the forensic evaluator would interview both parties and any of the subject children involved in the case, and then issue what's called a forensic examiner's report to the court. And in that report, they would make a recommendation as to what they think the best custody arrangement is in the best interest of the child. And when they're making the recommendation, they will weigh one or both parents' mental illness when making that decision. We have a webinar up on our website right now that was the first part of our child custody series, where we had a guest speaker who was a forensic evaluator, Dr. Paul Heimowitz. If you're looking for more information as to their reports or how they conduct their reports, that's a great resource, and it's available now on our website. And lastly, in this situation, the accusing parent can seek, as I mentioned in slide 1, an order requiring the other parent to undergo a mental health exam pursuant to New York Civil Law Section 3121. And the result of that would typically be the court appointing a forensic evaluator to evaluate one party or typically both parties. So next we'll move on to scenario C. And this is after being accused of a mental illness, the accused parent remains in denial. And this parent's outcome in a contested custody proceeding is going to greatly depend on how severe the alleged mental illness is. Some of the tougher mental illnesses to deal with in these situations are what are commonly referred to as cluster B personality disorders in the DSM-5. And that includes antisocial personality disorder, borderline personality disorder, histrionic personality disorder, and narcissistic personality disorder. So in cases like this where mental illness may be apparent, but the other parent is denying, it's almost a certainty that the court will appoint a forensic evaluator to evaluate the parties. And this parent, by either refusing to acknowledge they might have a mental illness or undergo diagnostic testing to see if they have a mental illness, is really harming their long-term custody prospects, because the denial or the subversion of having a mental illness reflects poorly on their parental fitness in the eyes of the court. So I've spoken a little bit about parental fitness, so I'll get more into that here. Parental fitness refers to a parent's physical, psychological, and financial ability to raise and nurture a child and to act in the child's best interests. And that's what's paramount in every custody proceeding, is what is in the best interest of the child. So if a person is suffering from mental illness, and as I noted in the previous slide, they fail to treat or address the mental illness, courts might look at that as they have a potential to harm the child or the subject children by not treating them, by not treating themselves or getting the help that they need. In general, the best scenario or the best course of action would be scenario A, where if you are mentally ill or the other parent is mentally ill, they're transparent with their treatment, they continue taking any prescribed medications, and they make their treating records available for all sides to examine. At this point, I'm going to turn the presentation over to our partner here, Maxine Donskoy, and she's going to speak to you all about the impacts of domestic violence on contested custody proceedings. Thank you.
Thank you, Shane, and good afternoon, everyone. Actually, October is Domestic Violence Awareness Month, and this was created to unite advocates across the nation in efforts to end domestic violence. Unfortunately, domestic violence is not ending, and it's more prevalent now than ever. So there needs to be unity all across the nation to end this terrible domestic violence. According to New York State Office for Prevention of Domestic Violence, on a typical day, there are more than 20,000 phone calls placed to domestic violence hotlines nationwide. And out of those calls, 1 in 4 women and 1 in 9 men experience severe forms of intimate partner violence. Approximately 1 in 4 women and 1 in 10 men have experienced sexual violence, physical violence, or stalking by an intimate partner. And more than half of all female homicide victims are killed by intimate partners. And just this past week in New York City, 2 domestic violence killings occurred. One was of a pregnant nurse who was killed by her boyfriend, and then her body was dumped near Queens Highway. And another was just here in downtown Manhattan, where a woman was fatally shot and killed by her estranged husband. And it's really terrible that most domestic violence killings occur when there is sort of a change in a relationship, like a pregnancy, or where one partner decides that they want to leave that abusive relationship. So you may be wondering, what exactly is considered domestic violence? The state of New York defines domestic violence as a pattern of coercive tactics, which can include physical, psychological, sexual, economic, and emotional abuse perpetrated by one person against an adult intimate partner, with the goal of establishing and maintaining power and control over the victim. This is a definition that was taken from the New York State Unified Court System, and the link is right here in the slide. Many types of abuse. So it's not only physical abuse. There's sexual abuse, emotional abuse, economic abuse, threats, which is a sort of psychological abuse, stalking, and now in today's day and age, there's something called cyber stalking, where perpetrators take to the internet and social media to stalk and harass and threaten their victims. How domestic violence is codified in New York. In New York, domestic violence is codified civilly in Family Court Act Article 8 and Domestic Relations Law Section 240. Family Court Article 8 also includes offenses that are enumerated in the New York Penal Code. So they are not only family offenses, they are also criminal offenses. Some of them are listed here, such as sexual misconduct, forcible touching, sexual abuse in the 3rd degree, and criminal obstruction of breathing or blood circulation. The next slide will show some more family offenses, which are also codified by the New York Penal Law. So there could be criminal repercussions thus far. So in addition to civil penalties, perpetrators of domestic violence can also face criminal repercussions for their actions. Criminal courts and family courts are courts with concurrent jurisdiction. So criminal charges may be brought by the district attorney's office in a criminal case against the perpetrator, but this requires the involvement of police officers. So in a criminal case, you don't participate in the case other than being a witness. The district attorney's office may have a victim witness coordinator who could assist you, but you will not be what is considered the plaintiff or the petitioner. In order to do so, in order to be more actively involved in a case, you would have to file for a civil order of protection where you are more in control of those terms. Because in a criminal case, it is the district attorney who brings the case and is in control of whether or not there would be a settlement and may even sort of drop the ball on the case. So that is why even if you have a criminal order of protection, you may want to get a civil order of protection as well. And if you have a pending divorce action and criminal charges related to that are brought, the case may be assigned to the IDV part, which is the integrated domestic violence part in the county where the actions are pending. How domestic violence impacts custody proceedings. a court must consider a finding of domestic violence in child custody proceedings. If there have been incidents of domestic violence, it is quite clear that mediation and joint legal custody is not possible. And that is because in order to have joint legal custody, you are supposed to be able to work with your co-parent in making decisions that are in the best interest of the child together. If you are trying to do that with an abuser, they may try to take control and threaten you if you do not do what they want you to do. So it's really not a possibility. If there are children involved and there are allegations of domestic violence, it is likely that there will be an investigation by ACS where they can do a court-ordered investigation of the home. They can interview the parties and the children. It's been said that children exposed to domestic violence have a higher risk for long-term physical and psychological problems, including depression, anxiety, and even heart disease. So pursuant to domestic relations law, the court must consider the effect of such domestic violence upon the best interest of the child, together with the other facts and circumstances of the case. So you might be wondering, what is the type of relief I can get if there is domestic violence in my case? You can ask for something called an order of protection, which is also known as a restraining order. As previously mentioned, you can get one from the criminal court or family court or both courts. In order to get a criminal court order of protection, there must be police involvement, and that's where the district attorney prosecutes. In the family court, in order for you to be able to file a family offense petition, you must have a certain relationship with the other person. You will either be current or former spouses, related by blood or marriage, have a child together, which is where the custody situation ties into place, have a current or former intimate relationship, such as an ex-boyfriend or ex-girlfriend, and that's, more than just a casual workplace relationship. And the types of order of protection, there's a refrain from, which orders a person to refrain from committing crimes against the other person or do anything offensive towards the other person. And this is something that we sort of call the usual terms order of protection. And one step further from that is the stay away order of protection, which in addition to the refraining from language, it contains language that requires a person to stay away from another person, his or her home, school, and work. And it could also prohibit contact with the other person, which includes third-party contact. So the perpetrator wouldn't be able to contact a third party to get a message across to the victim. That would be a violation of that order of protection. However, it should be noted that there could be some exceptions to the stay away order of protection or the no contact provision of the order of protection for a custodial situation, which would allow for visitation and or parenting time with the child or children, which may or may not be supervised depending on the level of abuse and violence in the home and the circumstances of the case. Due to COVID-19 pandemic and the current eviction moratorium in New York, it should be noted that the courts are noticeably resisting to order people to stay away if you cannot show that the person has an alternate place to reside and where the allegations are maybe not as severe or egregious. However, I do have some statistics here from the New York State Division of Criminal Justice Services, which says due to the ongoing COVID-19 pandemic, calls to the state's domestic violence hotline are up 30% in April compared to last year, and calls increased 18% from February to March 2020. The state police also reported domestic violence incident calls were up 15% compared to last year. Additionally, there was a 12% increase in intimate partner victimizations, which were reported by large police departments outside of New York City for the first quarter of 2020 compared to 2019. So you must know that, unfortunately, this relief is really imperfect. Orders of protection, they are not forever. They do have an expiration date. And sometimes times obtaining an order of protection places a victim in greater danger than not having an order of protection, because the abuser could try to retaliate against the victim for obtaining such relief. You should know that it is a piece of paper, and sometimes a piece of paper is not sufficient to stop a bullet or a knife. That's why I think it's important to have a plan in place. Seek treatment at a hospital if there is an emergency. Hospitals are a safe place. Call 911 if you're in immediate danger. Set up a plan with friends and family. Have bags packed in case it's necessary for you to leave. And you should know that there are lawyers available, such as us, who will be willing to talk to you, discuss your options, and move forward with some safety plans. And so on that note, I would welcome our founding partner, Patricia Fersch, who will be discussing allegations of sexual abuse in custody cases. Thank you very much.
Oops. Hello again. Before I begin, I did want to follow up on what Ms. Donskoy just said. I did have a case where I litigated custody after the fact. The mother had been murdered by the husband, and he then attached to her body, he knifed her to death. He attached the order of protection from Bronx Criminal Court. And so, to Ms. Donskoy's point, it is just a piece of paper, so you must have a plan. And the recent cases here that involve specifically the woman who told her husband she's leaving him and was murdered here in Lower Manhattan, I believe on Monday, she may be alive today had she had a plan. I'm going to talk to you about allegations of child sex abuse in a contested custody case. And the type of case that I'm referring to here are civil cases for the most part, although they can become criminal, and they often involve no physical evidence. So there's no physical evidence or medical evidence of sexual abuse. Generally, the allegations are inappropriate behavior, sexualized behavior, or inappropriate touching. And these allegations, once made, will generally involve Child Protective Services or CPS, or here in New York, ACS, Administration from Children's Services, who will begin an investigation. I would also note that in one case that I actually litigated, the mother who made the allegations against the father was my client, and she involved all of her friends and colleagues and other family members to call in other complaints regarding the allegation that this father was sexually abusing the child. Each time one of these people called in a complaint resulted in the child being examined yet again. And think about that. If you are allowing your child to be constantly or consistently over and over again examined, sometimes the question becomes, what does that say about you? And I'll address that a little more at the end in a case that I actually litigated up to the appellate division. If there is thought that it could be criminal, the Special Victims Unit will be involved. That's an arm of the New York Police Department, NYPD, and they will generally require, with the help of ACS or Child Protective Services, an interview at the Child Advocacy Center, also known as CAC. A prosecutor will be observing the interview. Children are often interviewed by sexual abuse experts. These are forensic doctors, psychologists who are trained in interviewing children and investigating allegations of child sex abuse. One of the methods that's used is the funnel approach. This is the examiner tries to create or have a relationship with the child, and then begins with very broad-based questions to the child about his daily routine, school life, and so on, and then moves to much more specific questions, even asking the child specific questions involving sex. And this does allow the interviewer to narrow the child's attention and focus very gradually without coming out and asking the obvious. So tell me, when did your father inappropriately touch you? Which would be an inappropriate question. Additionally, it is advised that parents not talk to the children or, in quotes, interview the child themselves, and allow all interviewing of the child to be done by professionals. The child will undoubtedly be appointed, if it's in New York, an attorney for the child, an AFC, that is an attorney who up and until about the age of 6 can substitute their own judgment for the child's. However, once the child reaches age 6, they must come into court and represent the child's wishes. Other attorneys will, the age is not codified, so that's not definitive. That's just a sort of general rule that most AFCs will claim that a child is infirmed. That is a legal term by age, and therefore substitute their own opinion. A GAL, if you're in a state where the court appoints a GAL, such as New Jersey, by example, that's a guardian ad litem. In some states, that is not even a lawyer. But in any event, a GAL is an arm of the court. So their role is to speak to the judge, essentially, and give their opinion as to, and remember, the burden of proof is always, or the standard rather, is best interests of the child. These are incredibly difficult cases. There is also a study that was done by Professor Joan Meyer of George Washington University. And in her study, she found that, and she makes the claim that there's a bias against mothers who make claims of sexual abuse. And in her study, she finds that it gets even worse for the mother if there is a forensic expert in child sex abuse called in, and if the child is appointed a GAL or, in our state, an AFC. Articles were written about Professor Meyer in the Washington Post, and also there is an abstract that she has published in which she in a very detailed manner and scientific manner presents her findings based on actual decisions of a judge. In my own cases, though, what I believe turned the table against the accuser, in both cases the mother, was their obsession with the allegations of child sex abuse. And in one of the reported cases listed here, matter of Penny B. versus Gary S., in that particular case, even though the forensic examiner had not found child sexual abuse, the mother insisted. And on one occasion, she went to see a cosmetic dentist and began, for I have no idea why, telling the dentist about her litigation with her husband and her allegations that he was sexually abusing their then about 3-year-old or perhaps even 2-year-old son. The dentist informed the mother that he had been a special victims unit investigator or prosecutor in Russia, and that he was very knowledgeable about these issues, and that he would volunteer to come to the mother's home to examine the child. And he did that evening. And the mother and he held up the child, and you all can have a visual of this, held up the child by his legs like a turkey at Thanksgiving, and photographed the child's genitals and rear end. And on these photographs, they were pointing to what was rather obviously a diaper rash. I'll also add that in this case, the mother did not tell the father that there was a prescription for the diaper rash, and rather, so each time the child went to the father, he's using a domestic over-the-counter product, and the child would get the diaper rash. And so the mother was using this against the father. So in this particular case, when it was argued before the appellate division, I stood up and all I had to say was Russian dentist. And the court had read the briefs. And this particular story about the mother's behavior, what she allowed to happen to her child, and then photographed it, thinking it's all okay, really told the tale about what the mother, or at least what the court believed the mother was trying to do, essentially keep the child away from the father. We would like to take your questions. I want you to know that all questions are anonymous. No one will know that you're asking the question. We don't publish it. Also, if you're interested, there is a recording, or will be a recording of this program available on our website. So if you didn't sign on today, or you would like to hear a particular segment again, it will be available on our website. All our other webinars are also available on our website. And all the slides here today will also be part of our Instagram account. And so you can see them there. So right now, I will be happy to take your questions. I want to also just tell you that our next webinar is scheduled for December 2nd. We're going to devote the entire webinar to issues of alcohol abuse. We will be discussing how to address alcohol abuse if you represent the client who is the abuser, how to address issues involved in custody litigation if you represent the parent accusing the other of being an alcohol abuser. And then we will have a guest, Stephen Paymer of Paymer Associates, who is an expert in this area. He provides the blow-in breathalyzers to litigants and spontaneous and also random testing that can be ordered by a court, so that if the child is with a parent, you can be somewhat secure that the parent therewith is not consuming alcohol, at least during the time of the visit. So now we're happy to take your questions. So the first question is, what if both parents are mentally ill, in denial, and not getting appropriate treatment? How would that situation be handled? In a situation like that, if these parents went before a court would undoubtedly have to call in Child Protective Services or the Administration for Children's Services if the court believed that neither parent was functioning at a capacity to care for the children. And if that is true, these children are likely to end up in foster care, which would be a very unfortunate result, and also a cautionary tale, because if there are two mentally ill parents, you really want to then keep the case out of court, and you want to insist that the clients get the treatment. Otherwise, they will literally lose their children. I'm going to ask Ms. Donskoy to take the next two questions. I'll read them. What constitutes cyber stalking and how can that be proven? And the second question, also about domestic violence, are there situations in which you would not recommend an order of protection?
So cyber stalking is using threats and harassment over the internet or social media, email, threatening to maybe post unwanted photos or blackmail emails or videos, or even hacking into somebody's social media and emails and using it for purposes of stalking, harassment, and threats to the other person to make them feel scared or in danger to lose maybe their job, or to have issues in school, or even their personal life with other people. And the way that this could be proven is it is a little bit costly, but there are forensic experts who handle this. There's also subpoenas that could be issued by lawyers, subpoenaing companies to show, maybe IP addresses and email addresses associated with these threats or accounts that are created online to bully and harass other people. And so that's as to cyber stalking. And then the other question is, are there situations in which you would not recommend an order of protection? And I think in those situations are where possibly the order of protection could cause more harm than good. Here, you know, the safety of our clients and their interest is most important to us. And so if there is a situation where the facts show that it's possible that retaliation may occur and that it could place our client in danger, we may say, you know what, it's probably safer for you to leave than order the other person out or get a stay away, just a piece of paper, and to have that safety plan where you would work with your family and friends to get you out of the dangerous situation. Okay, next question. I'll bring it back to Pat. Can a guardian ad litem's opinion be challenged by the court?
Sorry. We do have guardian ad litems, although we're more likely in this state to appoint an attorney for the child. The guardian ad litem, though, is an arm of the court. So I'll just simply say that. So to the extent that you would be essentially challenging a judge's opinion in challenging the findings of or recommendations of a guardian ad litem. And so the answer would seem to be yes, but in an appeal of the judge's opinion and the judge's reliance on the guardian ad litem's report. Where can we access the slides? The slides will be part of our Instagram feed, and so you can access them there. How do you handle mental issues like narcissism as it relates to parenting and best interests of the children when it is, when it is hinted at in the 730 but not diagnosed? This is an incredibly difficult issue. I actually wrote a little bit about this issue. I'm a Forbes contributor, so please feel free to pull up the article. You just have to Google my name and Forbes contributor and it'll come up. These are extremely difficult because, you know, you're dealing with someone who is a master of manipulation. I mean, a couple of bits of advice that I learned in my research: don't argue. You can't win an argument with a narcissist. Cannot win. Do not even try. And keep every piece of paper, every document you possibly can, because most likely the narcissist will set out to try to show that you are doing something harmful to the children and that it's them who is parent of the year. So keep every single record that you can and don't engage in their argumentative or threatening or whatever. Do not engage. How would you suggest child negligence, specifically emotional or psychological abuse? I think there's a sort of a typo in the question, but I'll answer it as what to do about it. If that's what you believe is occurring, the first thing I would suggest is, if possible, that you try to get the child into some form of psychotherapy, so that there is someone, a professional, who is able to deal with the child's concerns and issues, and perhaps what is going on with regard to the child. I think that's the last question that we have. We want to thank you for your time. Again, remind you, December 2nd, 1 to 2, Lunch and Learn. We will be discussing for the full hour alcohol abuse and various ways of handling it with regard to child custody. When we kick off again in January, we will be talking about financial issues. So the first segment will be devoted to the preparation of a financial affidavit, whether it's for child support or a statement of net worth. in a divorce case. Until then, we'll see you in December, but until we see you on December 2nd, a very, very happy and safe Thanksgiving. And a final note, please, please, please do not forget to vote. Thank you.